Good afternoon po sa inyong lahat at welcome po sa isa na namang edisyon ng Kalingang Katribu Legal Diaries. Ako po si Elmer Navarro Manuel at ang topic natin ngayong araw ay tungkol sa mga wills o yung mga tinatawag na, let's say, huling habilin, succession at saka inheritance o yung mana na tinatawag. Siyempre, para ipaliwanag sa atin to ng maayos, kasama natin ngayon ang Associate Lawyer ng Aranas Cruz, Araneta Parker and Faustino Law Offices na si Atty. Alfred Campañano. Attorney, good afternoon po.
Good afternoon, sir. Good afternoon.
Alright. Ayan, Attorney, ito, wills, succession and inheritance. Inheritance pala. Yan. So, pag-uusapan natin ngayon. So, siguro para simulan natin to, no, ano ba yung tinatawag na wills? O ito ba yung kung tama ba ako? Ito yung mga bilin na gustong i-ano ng mga kunwari may papamanahan siya, gusto niya, ito gusto ko, ito yung kasulatan. Yun ba yung tinatawag na will?
Tama actually yan, Sir Elmer, no? Yan yung that's the best or that's the simplest way na parang pwede nating ma-describe kung ano ang will. But under the law, specifically I think 739 of the Civil Code, dinidefine yan. Actually, a will is defined as an act by one person permitted wherein the person is able to control the disposition of his properties after his death to a certain extent. Of course, limited siya by law. So, yun yung parang operative definition natin. It is an act na kung saan if a person after that, it is an act by a person wherein properties niya that will only take effect after his or her death.
Okay, so ibig sabihin po,
so it's limited siya by law.
Limited lang siya kapag let's say namayapa na yung mag-iiwan ng tinatawag nila, ito yung sa mga pelikula to, yung mga last will and testament. Tama ba, attorney? Yan yung mga yun, di ba?
Yes, oo. Tapos ang kailangan importante at the onset pa lang na gusto ko nang i-clarify is will, may mga ang will is a strictly personal act.
Okay.
So meaning it's an act na ikaw yan. So dapat voluntarily mong ginawa yan, hindi ka pinuwersang gumawa ng will. So it is a solemn act. Hindi siya dahil sagrado, but because under the law, it has to comply with certain forms. So may mga formalities na dapat masunod depende on the kind of will that the decedent, the deceased had executed during his lifetime, and it is a unilateral act. So unlike ordinary contracts na it has to be by agreement, it's unilateral, similar to a donation, because it is upon the will, no? In the sense na it is basically the decision of the person whether to make a will or not, or whether to give his property to this specific person or not. So ang decision lang niya is whether to accept it or refuse it, but it's basically unilateral kasi nanggagaling mostly sa decision.
Okay. Alright, eto attorney, syempre dito sa Pilipinas hindi naman siguro gaanong uso yung pag-iiwan ng will, ano? Kasi syempre automatic pagka naiisip, ito tatay ko mayaman, pag namatay ito sigurado sa akin mapupunta to lahat unless meron siyang will. So, paano yun, attorney? Kunwari, wala talagang ginawang will, ano? Tapos, yun nga, namayapa yung magulang. Anong mangyayari dun sa properties na maiiwan ng mga magulang kung walang iniwan na testamento o yung will na tinatawag?
Kung walang will, it does not affect yung inheritance ng mga tinatawag nating heirs. So, hindi ibig sabihin na walang will, for example, ang inyong parents after they unfortunately passed away, hindi ibig sabihin nun na a portion only will go to you or baka mawala yung a portion of the property or the entirety of the property of your parent. And ang idea kasi niyan is that in the absence of a will, intestate succession kicks in.
Okay.
So meaning, we follow or kung kanino o kung ano ang makukuha ni mommy or ano ang makukuha ni dad, as the case may be. So govern as far as certain dispositions are concerned if it actually exists. But people need not worry if there is no will because ang fallback natin lagi dyan is the civil code or the laws on succession.
Okay. Alright, so attorney, nabanggit nyo na kung sakaling wala ngang maiwang will, ang sinasabi nyo yung parang merong automatic yung succession kung sino yung mga kasunod. Let's say kung parents yung nawala, syempre automatic sa anak mapupunta. Sila ba yung mga tinatawag na interstate o inherent heirs, mga ganun?
Okay. Ito yung, if I recall correctly, na-discuss natin to when we were talking about tax amnesty. Yung love descends.
Oo, tama.
Love descends, and love spreads. No? Kasi, so, basically, sila yung tinatawag mong compulsory heirs.
Okay.
Now, compulsory heirs, in the absence of a will, sila ang magmamana, and compulsory heirs sila is because even in the presence of a will, the compulsory heirs' inheritance must be protected.
Okay.
So, for example, huwag na tayo maghanap ng ibang magandang example dito. For example, may anak ako. Namatay ako afterwards.
Okay.
But before I die, diba, nag-execute ako ng will. Sinasabi ko lahat ng ari-arian ko, binibigay ko kay Elmer. Pero meron akong compulsory heir. Pero sinabi ko sa will is, ibibigay ko lahat ng ari-arian ko kay Elmer. Tapos tinanggap mo. So what does that mean? It means na mare-reduce ang mapupunta sa'yo. Kasi compulsory heirs the inheritance or the legitimes, yan yung legal term, no? The legitimes or the inheritance of the compulsory heirs must be protected and cannot be impaired. So, kaya nga di ba sinabi natin kanina, when you make a will, it is limited by law. Because whatever the law says as a minimum, or whatever the law says on how you're going to dispose of your property, it will always prevail over the will.
Okay.
Kaya nga ang sinasabi ng civil code is a will or the dispositions thereto is only up to the extent permitted by law.
Okay, so ibig sabihin pala, hindi totoo yung mga napapanood natin sa pelikula na iniiwan ko lahat ng ari-arian ko kay, let's say, kay Mang Dolphy. Tapos, si Panchito walang makukuha. Pero, in reality, meron talagang batas na magpoprotekta dun sa tinatawag na compulsory heirs. So, kahit pa paano, may makukuha yung pinag-iwanan talaga na base dun sa will, pero hindi pwedeng mawalan yung mga compulsory heirs. Okay, eto attorney, ano naman yung tinatawag na disinheritance? At saka ano ba yung mga grounds para, kasi parang pagkakaintindi ko rito, ito yung hindi ka mabibigyan ni singkong duling eh. Pagka namayapa yung mga parientes mo, kung sino man. Ano bang mga grounds nito para mag-take effect itong disinheritance na to?
Okay, again, a disinheritance, ganito siya, no? So, who are your heirs? Starts there. So, the heirs are basically, you have your compulsory heirs.
Okay.
So, yun yung sinasabi natin na love descends, ascends, and it spreads. Tapos, syempre, may mga limitations tayo dyan na kapag pag legitimate child, if buhay ang legitimate child, and then meron pa yung legitimate parent nung namatay, syempre, hindi maka-cancel out yung sa taas. Diba? But, if illegitimate child ang anak kong nabubuhay, for example, tas buhay ang aking legitimate mother, then they will inherit together. So may mga ganyang combinations and rules pa tayo on the laws on the succession. Now, why am I distinguishing this? Kasi may mga tinatawag tayong heirs na legatees or devisees. So dito pumapasok yung, kunwari, yung properties ko is composed of, let's say, a parcel of land,
okay,
or a condominium unit, and a car. So, legatees and devisees, ang tawag. Devisee, kapag yung heir na yan will receive real properties from me through my will, and legatees if they will receive personal property by way of will na ginawa ko. Now, why is this important? Because this inheritance becomes a matter of issue involving compulsory heirs.
okay.
Most of the time. So, ngayon, ano yung grounds? Now, mahaba-haba siya actually na enumeration. So, I would direct na lang yung mga viewers
yung pinaka-medyo
to Article 919. So, sabihin ko na lang siya. No? So, if descendant ang hindi disinherit mo. Kasi pag when you disinherit, it's basically a will. Kasi di ba when you make a will, pwedeng hindi ka nagsasabi na, sasabihin mo na, di ba ideally, sasabihin mo na your properties go to A, B, and C.
Iiwan
di ba parang ganyan? Di ba? That's basically our common understanding of a will.
Tama.
A disinheritance or an act of disinheritance can also be done by way of a will. Meaning, hindi ka nagsasabi kung kayo na mapupunta. Pero sinasabi mo na hindi magmamana ang anak ko na ito, o hindi magmamana si mother or si father or si pinsan, etc. Now, ngayon, if descendant ang i-disinherit mo, so basically, ito yung common grounds. Whether descendant, ascendant, or spouse ang i-disinherit mo. When either of the heirs accuse the testator of a crime, punishable with imprisonment for more than 6 years, and is found to be groundless. So meaning hindi siya totoo. Tapos nagsampa ka ng kaso. Ba? Second, common ground between descendant, ascendant, or spouse is if the heir, yung i-disinherit mo na heir, is found to be guilty of an attempt against the life of the testator, his or her spouse, or any of their descendants or ascendants. So, ideally, the situation here is, kung may asawa ka, kunwari anak kita, Sir Elmer, may asawa yung nanay mo. Ba? Anong nangyari, nalaman ko, sinubukan mong patayin ng asawa ko.
Tama.
Disinherit kita. Pwede kita disinherit on that ground. Tapos, another common ground to disinherit a descendant, an ascendant, or a spouse is yung unjustified refusal to give support. So yun, di ba, for example, ito yung, di ba, for example, throughout your childhood, may hindi siya yung isang, for example, missing in action yung tatay mo. Tapos nung lumaki ka, yumaman ka bigla. That's actually a ground for you to disinherit the father.
Tama.
Kasi that's basically abandonment. Or in this case, an unjustified refusal to, whichever the case may be, no? Particularly to a descendant, may mga particular grounds dyan for descendants, ascendants, at saka sa spouse. Again, mahaba-haba information yan. Even nung law school ako, I only memorized that for purposes of passing Attorney Reyes' class. Pero other than that, nakalimutan ko na because it's big listing. So I suggest, again, to go to Article 919, 920, and 921 of the Civil Code to check the grounds for this inheritance. Now, why am I referring you to these sections? Because these are exclusive lists.
Okay.
So anything other than this, hindi siya pwedeng maging ground for this inheritance.
Alright, okay. Alright, attorney, magbe-break muna tayo saglit. Huwag po kayong aalis at babalik po muli ang Kalingang Katribu Legal Diaries.
Magpabakuna kayo.
This public service advisory is brought to you by Daily Tribune and 100.3 RJFM.
Magandang araw mga katribu! Narito na ang mga makakasama nyo tuwing umaga sa programang Gising Na. Roy Pelovelo, Compi Manalo, Chinky Mangkukang, Vernon Velasco, Kim Sancha at Chirk Balagtas. Abangan ang programang Gising Na mula alas 8 hanggang alas 9 ng umaga sa Facebook page ng Daily Tribune.
Ilabas ng mainit na kape at samahan kami sa inyong pag-almusal, mga katribo.
Sama-sama natin alamin ang mga natatagong istorya sa mga latest na kaganapan sa loob at labas ng bansa.
Simulan ang bawat umaga with good vibes sa mga informative and recreational segments dito sa ating programa.
Maaari niyo rin ibahagi sa amin ang inyong opinion via Daily Tribune Facebook page at Tribune Now sa YouTube.
Makichika na rin sa latest showbiz happenings, mga katribo.
Kaya naman, magkita-kita po tayo mula Lunes hanggang Biyernes, alas 8 hanggang alas 9 ng umaga at magsama-sama po tayo sa
Gising Na!
Magpabakuna kayo.
Nagbabalik po muli ang Kalingang Katribu Legal Diaries at syempre kasama pa rin natin si Atty. Alfred Campañano. Alright, Attorney, ito, nabanggit natin kanina no, yung mga tungkol sa mga wills na tinatawag. Meron bang mga iba't ibang klase ng wills? Gaya nung sinabi mo kanina, yung will para pag-iwanan, tapos pwede rin gumawa ng will para ayokong pamanahan, parang ganon. May iba pa bang klase ng ganitong wills na tinatawag?
Basically, kasi ang will is under the Philippines. Answer first the question, under the Philippines, may dalawa lang wills na nire-recognize.
Okay.
Tinatawag tayong holographic will. Na may mga tinatawag na reciprocal or mutual wills, joint wills, yung mga ganyan, na kung saan it's not valid here in the Philippines. Because, as I mentioned a while ago, is it violates the, what you call this, it violates the personal act.
Okay.
The characteristic that a will is a personal act of the testator. Now, a holographic will is a will that is handwritten by a person. Siyempre, handwritten lang. So, handwritten. Deceded. Well, during his lifetime, of course. No? So, that's basically your holographic will. While a notarial will showing yung dispositions, conditions, or whatever testamentary provisions of the will na gusto i-introduce ng testator, of the testator into that document. Tapos, it's basically a notarial will because there is an attestation clause and it has to be acknowledged before a notary public in the Philippines. Now, I mentioned a while ago the idea of foreign wills, no? Yung mga yung joint wills, etc. Whatever the form, remember, when it comes to the formalities of a will, diba, we follow the law on where the same is executed.
Okay.
Now, depending on the nationality of the person who made the will, that will actually govern the formalities of the said will. So, for example, di ba sinabi ko kanina, foreign wills or joint wills or reciprocal or mutual wills are not recognized here in the Philippines.
Tama.
So, if for example, may Filipinong nag-execute ng will abroad, pero Filipino pa rin siya, pag pre-novate yan dito, meaning probate, basically it's a fancy legal term to say na valid ang isang will. If pre-novate yung joint or reciprocal will na yan, the chances are that will be invalidated. Because Filipino ka, you are governed by the formalities of Philippine law in making the will. Iba ang pinag-uusapan natin if foreigner ang gumawa ng will and then may mga properties siya dito. So we look at the formalities kasi strict tayo sa formalities. Remember, unlike succession or you get the inheritance or the dispositions thereto takes effect after the death of a person. So, kaya tayo strict sa formalities because hindi na makakapagsalita yan. Touch move yan, technically. Hindi na maririnig yung tao na yan na sasabihin mo, hindi yan ang ibig ko sabihin when I wrote the will. Diba? So, matakot kayo kung nag-media board kayo siya.
Biglang nagpakita. Teka, hindi yan yun.
So, kaya tayo strict sa formalities.
Okay. Alright, so ibig sabihin pala, attorney, yung dalawang klaseng wills na talagang dito lang sa Pilipinas may execute ay ang holographic at saka yung notarial. So parang sa madaling sabi, yung holographic parang yung tinatawag nilang informal will. Kasi sabi mo, sulat kamay nga, o baka siguro nakita niya sa mga kung sino-sinong abogado, tapos pinanotaryo. So, yun. Okay. Paano ngayon, attorney, kunwari, let's say, kunwari ako, malapit na ako madali, gumawa ako ng kasulatan, no? Tapos, last minute, sabi ko, teka, parang mali yata yung pagbibigyan ko, papalitan ko to. Tapos, habang in the process na pinapalitan mo, na-deads ako, paano yun? Sa original pa rin bang sinulat ko mapupunta o may pag-asa pa yung pinagbaguhan ko ng isip, yung isusulat ko dapat?
Sir, bago ko sagutin yung tanong na yan, kailangan ko lang ma-emphasize na ingat kayo sa pag-execute ng notarial will. Because a notarial will is very strict, especially when you submit it for probate. So, may mga forms yan na hindi naman forms, sorry. May formalities and requirements that the law specifically requires. Na dapat it has to be in writing, subscribed by the testator, and 3 instrumental witnesses, attested to before the notary public, paginated, signed in each and every page, etc. If magkaroon ng error in one of these formalities, then there is ground to disallow there is ground to invalidate the will. Right? Now, going back then doon sa intention mo. Say for example, nag-execute ka ng notarial will. And then again, para ko na rin, bibigay mo, say for example, hindi na lang tao ang binago mo. Para, hindi pala yung BMW ko. Ang ibibigay ko na lang
yung Ferrari.
Yung Rush ko or Ferrari ko na lang. Diba? Ngayon, a will can be modified by a holographic will or a notarial will or may mga tinatawag tayong codicils na tinatawag na kung saan pwede ka mag-introduce ng changes or amendments to your testamentary dispositions in the earlier will. So there's actually it's actually a source of confusion in legal issues yung mga ganyang situation. But as basing only or solely on the facts that you mentioned, if namatay ka,
Oo nga.
sorry, if namatay ka, bago mo mapalitan yung gusto mong mangyari, then yun ang mag-govern. The will itself. Now, you can try to say na hindi yan yung intention, but again, remember, a dead man cannot talk. So magiging
dead man,
dispute yan between the air. Nasasabihin mo, hindi naman nakasulat yan eh. Who's to say na sinasabi mo lang or you're just iniimbento mo na binabalak na talagang palitan. Right? So, the lesson there is when you make a will, make sure na iyon na. And if you really must change a provision there too, then dapat palitan mo lang din.
Madaliin mo agad. Tama. Okay, eto attorney, syempre yung iba, let's say may mga gantong kaso na siguro, lalo sa pelikula, talaga ito, madalas to, na gusto kong pamanahan pero ayaw mo. Pwede mo bang tanggihan yung ganon? O kunwari, yung anak ko, papamanahan ko, ikaw na susunod, ikaw na hawak nitong mga negosyo na to, pero ayaw niya. So, pwede ba yun na tanggihan niya tapos ako nang bahala kung kanino ko ililipat yung succession? Kunwari, ako yung CEO nung kumpanya namin ng bigas, gano'n. So, pwede kung ayaw niya, pwede ko ilipat sa iba. Parang gano'n.
Gusto ko lang muna malaman kung ano yung kumpanya ng bigas na yan. Naging CEO anong bigas na kumpanya.
Oo nga eh.
Kidding aside. So basically, ang concern mo is kung what if ayaw niya yung ibinibigay sa'yo. Right? Tama po ba?
Oo, kung ayaw niya nung binibigay ko sa kanya. Ayaw niya nung binibigay ko sa kanya.
May kasabihan eh, na you cannot there's a saying that you cannot force a goodwill down the throat of a person.
Oo, tama.
Diba? So, ang idea niyan is similar to a donation. Diba? If a person does not want that donation, na binibigay ko yung BMW ko, ay hindi, ayoko, huwag mo ibigay. Then, wala kang choice. That goes back to the estate. And then, syempre, kung walang alternative or walang substitute, in this case, car, no? So, walang substitute legate, then, it goes back to the estate, then magpa-apply ang rules on legitimes and intestate succession. So, ganun yung idea niya. Now, if your question is, ayaw ko yung kumpanya ng bigas.
Tama.
Ang gusto ko ay kumpanya ng langis. Diba? Again, it goes to the characteristic of a will that it is a strictly personal act. So, the heir cannot dictate, diba? Cannot dictate what the testator wants to give you.
Tama.
Parang ang tigas naman ng mukha mo.
Oo nga. Binibigyan ka pa nga.
Binibigyan kitang BMW, hindi ayoko yan eh. Gusto ko dalawa, parang gano'n. So, ganun yung idea niyan. So, how do you express that renunciation? More often than not, basically, pwede mo lang pwede naman na, kasi literally, wag mo nang tanggapin. Kapag inaabot na sa'yo. Kasi remember, na-probate na siya, for example, and i-distribute na, is-settle na yung estate. Either judicially or extrajudicially, meaning by agreement, then wag ka mag-participate sa estate, sa extrajudicial settlement, or in the settlement itself, doon mo i-manifest ang refusal mo to accept the donation.
Okay. Alright, siguro, attorney.
And then of course, again, in a tax firm, may mga complications yan or tax implications. But again, that's a separate topic altogether.
Alright. Attorney, magbe-break lang tayo saglit. Pagbalik natin, tribunal tayo. So, huwag kayong alis at babalik pong muli ang Kalingang Katribu Legal Diaries.
Magpabakuna kayo.
This public service advisory is brought to you by Daily Tribune and 100.3 RJFM.
Vaccination, isolation, gotta keep up with my nutrition, gotta maintain my body condition, then I can take my vaccination. What do I choose? What do I take? As long as it is not a fake. AstraZeneca, Moderna, BioNTech, even Sinovac, okay na. Babakuna ka ba? 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 Vaccination for the nation, no more isolation. With vaccination, babakuna ka ba? 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 Paturok, paturok, paturok.
This public service advisory is brought to you by Daily Tribune and 100.3 RJFM.
Magpabakuna kayo.
Nagbabalik po muli ang Kalingang Katribu Legal Diaries at syempre kasama pa rin natin si Atty. Alfred Campañano. Alright, Atty., eto, tribino tayo. So, para sa ating tribino ngayong araw na to, alam nyo ba na ang illegitimate child proven his or her maternity ay... teka lang medyo...
Harangan.
Oo, mukhang naghang eh. Ayun. The illegitimate child proven his or her maternity is also entitled to 1/2 the share of the legitimate child. So, entitled yung illegitimate ng kalahati ng share ng legitimate child. Tama ba to, attorney? Ito yung pinag-uusapan din natin kanina, di ba? Yung sabi mo, yung mga legitimate tsaka illegitimate na mapapamanahan.
Yeah, actually, that's basically correct, no? The situation contemplated there is yung mga maraming scholar.
Ay, ayun na.
Na tinatawag.
Maraming pinapaaral.
Pero ang legitimate na pamilya, tapos may mga pinapaaral kita. Kidding aside. So, yung idea niyan is meron kang mga illegitimate children. So, while the law recognizes that they are compulsory heirs and they will not cancel each other out, no?
Okay.
Diba? Meaning, legit, kunwari, Sir Elmer, magkapatid, no? Ikaw, ano gusto mo? Illegitimate ka o illegitimate?
Ako muna yung illegitimate.
Anak sa labas, anak sa loob.
For argument's sake, kaya.
So, ikaw, anak sa loob. Tapos ako yung anak sa labas.
Okay.
Ngayon, ang mangyayari niyan, so magkapatid tayo, namatay kunwari ang ating fictional na tatay, kaya ang mangyayari dyan, supposedly, hati tayo. Pero, meron tayong rule na ako will only get to inherit 1/2 of the share of the legitimate child. So, para kung 50% sa'yo, 25 lang mapupunta sa akin.
Tama.
However, kailangan natin mag-ingat sa tribuno na yan, no? Because yung sinasabi that you only get to inherit 1/2 of the share of the legitimate child, but an illegitimate child is only entitled to 1/2 of the share of a legitimate child. Depende pa, we're only talking about here the legitimes, no? So there is a possibility na ultimately mag-equal lahat because of the predisposable portion of the estate. Kasi syempre meron kang parang pie. Yung legitimates kasi kailangan i-set aside mo na yan. So it's basically 1/2 yung sa illegitimate child, then the rest goes to the legitimate children. Pero again, pwede ma-equalize yan by virtue of a will.
Tama.
So, yun yung inaano natin dyan. So, ingat lang din sa tribunal kasi baka naman may will si decedent para naman fair. Kasi, di ba, di mo sisisi yung bata, etc. and all that.
Alright, okay, attorney, medyo ito na lang yung oras natin ngayon. So, bago tayo magtapos, any parting shots tungkol sa topic natin ngayon na wills, inheritance, at saka succession?
Well, sa wills, no, that is one way of we encourage the making or the drafting of a will to avoid any after the fact controversy. Na parang siguro naman at the time bago ka namatay, alam mong hindi na pag-aaway-awayan ng mga anak mo. Kasi sino bang magulang ang gustong nag-aaway ang kanilang mga anak? Although syempre may times na binibigyan tayo ng kutsilyo ng ating mga magulang. Sige, magpatay na kayo.
Sige.
Di ba? That's basically exage lang yan ng ating mga magulang. So parang ultimately ayaw naman natin nakikita nag-aaway-aaway tayo just for property. So it's always good to plan ahead, no? Na this is basically through your will, and of course, syempre, since again I keep on saying that there's going to be a tax implication, that is always good to plan your estate ahead if you already have a significant amount of property. Para also at the same time, hindi madadalian ang mga heirs mo or the loved ones that you will leave behind once you actually pass.
Okay, alright. Maraming salamat sa oras mo ngayon, Atty. Alfred Campañano, at magkita-kita po tayong muli sa susunod na Biyernes para sa isa na namang edisyon ng Kalingang Katribu Legal Diaries. Muli po ako si Elmer Navarro Manuel at magandang hapon po sa inyong lahat.